Hey guys, this is the 3-minute tutorial on United States Patent and Trademark Office non-final office actions. This is a non-final office action, and that office action regards this system that we've used in other examples for the walking through walls training system. So this is an application, and this is an office action regarding that application. So here you have your application number, your filing date, your first named inventor. You'll only have a first named inventor here, no other inventors. There's no attorney docket number here because it was a pro se filing, so that means that the inventor slash applicant was the same. They didn't go through a attorney or a firm. And then you have your confirmation number here, which is useful for initiating dialogue with your examiner, who was listed here, and the examiner's art unit. This is your mail date, which is useful for determining when you need to reply statutorily, and that is basically all of your first page of the non-final office action. This is your summary thereof. Again, you have a lot of the same information. It tells you that you need to respond in 3 months because this was in fact a non-final office action. For final, it's usually 2 months, so that's why they mark it 3 months there. 1 through 6 were pending, 1 through 6 were rejected, nothing's allowed, nothing's objected to, and nothing's restricted, at least from the claims perspective. The specification appears to be accepted, however the drawings were objected to, and there was no claim for priority, foreign priority under 35 U.S.C. 119. This is the detailed action, as we discussed before. The drawings were objected to because they are dark and include shading which obscures the figures. That's just the reason they gave. And then you have a 101 objection here, which talks about the lack of utility. As they talk about in this page, there's a substantial lack of evidence that a human is capable of breaking the well-accepted laws of nature to, kind of shift through walls, basically, which was the focus of these claims. Accordingly, because, a person having ordinary skill in the art wouldn't know how to do that, they can't comply with 112, which demands that a person having ordinary skill in art would be able to operate the claims. There's also an antecedent basis rejection here under 112, which means that they didn't refer to terms consistently throughout their claims. And then you have your 35 U.S.C. 103 obviousness rejection here, which just says that, even though there's no utility, we found art that's relevant, and in this case, there's a dance that does some similar movements to what was claimed, and that's what they're going to use for the obviousness part. They also took official notice, which means that they didn't actually find prior art. They're just saying that this is known to be done with regards to the periodic symbol or signal that's used with the dance instruction. And then you have conclusion, some prior art made of record that was not relied on in the 103 obviousness rejection, and how to contact the examiner.